Yes. Thank you, Ganesh, for that introduction. Now, I think you can all hear me. It's a matter of whether you can all see me. Okay, ladies and gentlemen, from Hong Kong, I bring you greetings at the beginning of the year 2016 of happiness, good health, and harmony. Now, harmony is what mediation strives to achieve. And that brings me to the theme of my discussion this morning as to, in IP disputes, whether mediation is the path forward. I came to India in 1990 and in 2004, and the economy of India then was quite still at a baby stage. But now in the year 2016, India's economy has improved by leaps and bounds, and the world is really impressed by the way that India is progressing in its IT industries, its pharmacy industries, and also the entertainment with copyrights in movies and also music. So, as far as we're concerned, when economic activities strive, then there is a race for intellectual property to be created, and there is a growing importance for enforcement and protection of intellectual property rights. Now, I know that I'm speaking to experts here, but just so that we are all on the same page, I've prepared just this slide to show what I call the hardcore intellectual property. Those would normally be trademarks, patents, registered designs, sometimes utility patents, copyrights, passing off. In Hong Kong, we have a common law action of being able to prevent a defendant from using trade dress or slogans or badges of trade, what we describe as badges of trade, which might be confusingly similar to the plaintiff. And there would be issues on competition, which we have also heard about this morning. Now, and then there is a larger field of what I call loosely matters which IP lawyers would also deal with. This would be confidential information, duties of directors, partners, and employees, duties of distributors, contractors, licensee, and franchisees. Now, these are rights and obligations which might be created by law or by contract. Now, and then there is downright fraud. So when we have so many obligations and rights involved, there is also a higher potential of disputes arising. When disputes arise, what happens? We all know about the long ongoing saga of Apple and Samsung. It's been going on for the last 4 or 5 years, and we're expected to see at the beginning of this year the 4th jury retrial. The legal cost was so phenomenal that actually Judge Cole commented that the parties should seriously consider going for alternative dispute resolution. So if we have a dispute involving intellectual property matters, what happens? What are our options? Of course, on the one hand, we all know about going to the courts, but that can be expensive, even if less expensive than the Apple case. And of course, you have a choice of surrendering, not doing anything, but we're not going into any discussion on that this morning. Then there is the option of arbitration, which is like a mini trial. And the green light, which I'm trying to show, is actually for mediation. Mediation is an alternative dispute resolution process. It is voluntary because nobody, well, unless the law requires it, otherwise the parties should willingly and voluntarily enter into it. It is private in the sense that it's not open. It is confidential. Matters discussed during mediation remain confidential. And then there is the mediator. The mediator is a trained neutral party who facilitates the parties to reach their own negotiated settlement agreement. So, what are the advantages of going to mediation? First of all, in comparison to court proceedings, mediation is very quick. Now, in cases where parties have pre-agreed to go to mediation, and I will be dealing with that slightly later, where they have pre-agreed for mediation, that can be even quicker. In Hong Kong, where the procedure for the Hong Kong International Arbitration Center is employed, you can have a case resolved by mediation within 42 days. So whereas in litigation, many times a trial actually takes years to go to court, in mediation we can be talking about in terms of weeks and even days if it is very, very urgent. And secondly, mediation is confidential. All the discussions, all the documents disclosed during mediation remain inside the four walls. And the parties have to agree to the confidentiality, and non-parties who are participating as observers or friendly advisors or even their professional advisors should be under a duty of confidentiality as well. Mediation is under the party control, which means that the parties have a very large say about how they want to run it, who they want to entrust the case to, and the solution to be reached. It's up to them. They decide. They don't have a court judge sitting over them. Then mediation is also very flexible because it's really up to the parties to agree. And the relationship in any kind of a contractual situation, that can be preserved through mediation because one, if the painful dispute can be resolved very quickly and people can get over it, that retains the goodwill between the parties, but also because the parties are able to sit down together in a room in front of the mediator, that actually brings about a degree of goodwill as well. And many times we discovered in mediation that it is the need for a party to be heard, that when he feels that the other side has heard him out, whether they agree with it or not, heard out his grievance and why he feels so hurt, then that is when what we call healing or a spirit of goodwill is then generated, which allows the parties to proceed to think about how to resolve a matter in a practical manner. Now, because mediation is quick, of course, it is cost-effective. And being confidential, it is also without prejudice. This means, apart from the usual term, that unless an offer is accepted, then it remains without prejudice. But it also means that even if the mediation fails, none of the things which were discussed during mediation, none of the evidence disclosed could be produced to the judge. So, because the parties are in control as to how they want to run the mediation, they also have a choice. I don't know about the Indian courts here, but in Hong Kong, intellectual property disputes are actually adjudicated upon by our usual judges. But in mediation, it's open to the parties to appoint somebody who is a specialist mediator, or in other words, somebody who is familiar and experienced with IP laws and practice. So being flexible also means that the parties and the mediation is not restricted by court rules. Now, this is very useful because I think we're all the experts here. We know how a case can actually get bogged down by court procedures and it may take summons after summons and court hearings before you actually get to adjudicate upon the substantive issues in the case. So here in mediation, you can do without all those. But of course, in the mediation, parties who are represented by the litigation lawyers, the lawyers can explain to the other side and say, all right, if in this lawsuit you are going to say this, this is my counter-argument. And so it runs as if it's like a game of tic-tac-toe, that the parties are orally able to give a verbal argument and discussion about the pros and cons of the case, so that they reach a much better understanding about the strengths and weaknesses of the case. And of course, all that discussion cannot be disclosed to the judge anyway. And because there is a possibility of preserving relationship, it also means that it is better business for the parties. And when I was discussing with some of my professional colleagues here, they asked me to also include here that it is also better business in the sense that when you're a litigation lawyer, sometimes you may end up not being paid. But if you're a mediator, you will always be paid. So a discussion would not be balanced without talking about the cons of mediation. And the critics say that if you go to court, you get an open trial. You know which are the witnesses who attend, you know what they say, and there is also press coverage. So society also knows. Whereas in mediation, because it's a confidential process, it's done within four walls. So society will not know about the case, not even about the fact that the parties are in mediation. But of course, the parties can publicize that fact as well. It's up to them. So in a court, there is judgment, but in a mediation, there is no judgment. It's simply a matter of a settlement, which can be embodied either in some form of a contract, and also, in many cases, by way of a consent judgment in court. So where there are registered rights involved for intellectual property, the critics say, how are you going to deal with issues like invalidation? How are you going to deal with rectification of, for example, the trademarks register? And so here, what we say, the mediators say, that the parties can actually agree. The parties can agree what to do with it, and then obviously it will be subject to the court's final approval, or in the case where registries are concerned, they would have to register them. But I am sure that with expert solicitors and expert attorneys in IP, they would be able to assist in formulating some sort of a judgment and contract which will satisfactorily bring about the same outcome. So enforcement in the courts, we all know, is mandatory, but whereas in mediation, it's voluntary and it would depend on goodwill of the parties. So one very special aspect of intellectual property is that usually it's multi-jurisdictional. Instead of running parallel litigation in a number of jurisdictions, what mediation can do is to have multi-parties join in and have the whole matter resolved once and for all. Now, for cross-border solutions, this really works. And I've had cases where, in fact, the company a Hong Kong company has subsidiaries in China, where enforcement and litigation will actually be quite terrific. But because there was a willingness to come to a settlement terms, there was a willingness to abide, and so you don't have to go through all the difficulties of having to enforce them in different jurisdictions. So how do we bring about a mediation in a pretty quick time? Now, the Indian Supreme Court in the case Enercon was discussing about an arbitration clause there. And it brought out the importance of the differences between having a governing law pre-agreed upon, which is quite usual for contracts, but also a choice of forum where dispute comes up. And so you might say, why do we bother to put in such a clause when I'm trying to get the business running first and it's all voluntary anyway? Now, I would say, from a practical point of view, if the parties pre-agree to have a preset procedure, that if disputes arise, we're going to mediation and we're going to this particular place, then it manages expectations and time, and often IP lawyers would know that no one need to appear weak for the person who proposes sitting down for a settlement discussion. So whilst we're considering a mediation clause, I'd like to invite parties to consider using Hong Kong as a forum, as the venue of the mediation, because Hong Kong is a special administrative region on China soil. We have an independent legal system. As a former British colony, we have the common law system, and we have strong legal traditions where the rule of law is going strong. We have a body of well-trained professionals and specialists, and we are fully bilingual in Chinese and English. Foreign law and technical experts are easily accessible, and particularly where you have one party being in China, enforcement is easy. And of course, Hong Kong, I think a lot of you know, is ease of traveling and good infrastructure. We have hotels, etc. And there's a government policy of promoting Hong Kong as an IP trading hub. So I've given the website there if anybody is more interested in reading up more. And for the China policy, they are promoting the One Belt and One Road, and India also features in there. And there is going to be more proliferation of economic activity along the trade corridors, which of course increases the chances of disputes. Now, I've just put on that one slide which shows that if you come to Hong Kong and use the procedure set down by the Hong Kong International Arbitration Center, it's relatively easy. Each party will pay upfront US dollars 130. Now that's to the center. And what it does is that it has panels of mediators who are trained in different areas. And you get to choose, you get to veto, whichever mediator is proposed to you. And the appointment of that particular mediator is for 3 months. In the quickest time, you can have your mediation heard within 42 days. But of course, where we're talking about international issues, it may take more time for the arrangements. So I leave you, as a parting gift, I leave you a suggested mediation clause that you can read it there. It's a very simple form that the contract will be governed by Hong Kong law, and disputes arising shall first be referred to mediation at the HKIAC and in accordance with the then mediation rules. If anybody's interested in reading more, that's the website there. And out there in the reception, I've also put a handout by the Mediation Council, which talks in more detail about the advantages of going to mediation. So thank you.
Thank you. Thank you very much.